Last year, a constituent of mine, Daphne Franks, came to my advice surgery on a Saturday morning to tell me the horrifying story of her mother, Joan Blass, a story that I could hardly believe was possible in modern Britain, but one which showed clearly that our marriage laws were sadly deficient in one important aspect, one which has provided the reason for my bill this afternoon. Born in April 1924 and widowed in 2008, Joan Blass lived next door to her daughter in the Gledow district of my Leeds North East constituency. Towards the end of 2011, Joan was working in her garden one afternoon when she met Coleman Folan, who struck up a conversation with her whilst she was standing at the gate from her garden to the street. She invited Mr. Folan into her home for a cup of tea, and within 1 month of their first meeting, Coleman Folan had moved into Joan's house, taking up residence in her spare bedroom. Joan had been diagnosed with vascular dementia in early 2011, and at first it appeared that Coleman was looking after her very well, although he seemed to be rather controlling and secretive. He also became increasingly hostile towards her family. He began to take Joan to visit her friends, as well as some relatives, all over the country, and in 2015, he and Joan flew to Budapest, even though by this time she was getting very frail and travelling made her stressed and exhausted. For the 10 days they were away, Daphne, her daughter, had no idea where she was. Sadly, on the 26th of March 2016, Joan Blass died of cancer, not long before her 92nd birthday. When her daughter saw her shortly after her death, she was still wearing her first husband's wedding ring. But it was 3 days after her mother's death that Daphne discovered that Coleman and Joan had been married in a civil ceremony at Leeds Town Hall on the 26th of October 2015. Madam Deputy Speaker, members of this House may imagine what a shock this discovery was to Daphne, her brother, and to the rest of Joan's family. At the time of the marriage, Joan was 91 and Coleman was 67. No family member or friend had been told about the secret marriage ceremony. Daphne asked her solicitor and the police for help and recalled that Coleman had stopped even communicating with her or any other family member in 2014 for no obvious reason. Although Daphne continued to see her mother every day in her home, she always felt a little bit frightened of Coleman. Joan had made a will some years before meeting Coleman, but Daphne discovered, to her surprise and shock, that a marriage automatically revokes a previous will. Coleman now had complete control over Joan's estate, in spite of the fact that Daphne previously had power of attorney on behalf of her mother during her mother's lifetime. However, the solicitor advised the family that it was almost impossible to annul a marriage after death, and that the only grounds upon which a marriage could be annulled would be that if it could be proved that either partner had a lack of capacity to make a free and rational decision to marry. Unfortunately, no such evidence existed. And yet, further pain was caused to Joan's family after her funeral wishes were denied by Coleman. Joan had always made it clear that she did not wish to be buried after her death, yet Coleman insisted. The family's solicitor advised that a single day's hearing at the Leeds Division of the High Court would settle the matter in Joan's and the family's favour, upholding the wishes of the deceased. However, after a 4-day hearing, costing the family all their savings and assets, more than £200,000, the judge ruled in Coleman's favour, because Joan had never actually written down her wishes. Furthermore, Madam Deputy Speaker, if it had been possible to annul the marriage, an annulled marriage cannot overturn the revocation of a will through marriage. Parties in a marriage must understand the financial consequences of entering into that marriage. See the Court of Protection judgment, EJ versus SD 2017. So, Madam Deputy Speaker, this afternoon I'm presenting my bill in an attempt to close some of the loopholes in the statutes that govern marriage in this country. It's not good enough for a registrar simply to say that because one of the participants in a marriage ceremony was smiling at the time, that meant consent was happily given. Much of the anecdotal evidence suggests that Joan had no idea she had ever been married to Follen, and that there was clear evidence her mental capacity was severely reduced in the last years of her life. Yet there is no requirement for registrars to ensure that both parties in a marriage are aware of what they are doing when they enter into a contract to be married. There are protections under the law to prevent marriage under duress. But believing that duress is not present simply because one of the parties looks content does not mean that there is the mental capacity for that consent. Madam Deputy Speaker, my bill would establish a number of improvements and protections against what I would call predatory marriage, a phrase already in circulation in Canada and now used by Joan's family. The Marriage and Civil Partnership Consent Bill would, amongst other issues, establish, firstly, that marriage should no longer revoke a previous will in every case, or indeed in any case. The majority of those affected are entering into second marriages and are from the older generation. 2, that there should be better training for registrars to ensure robust procedures for safeguarding vulnerable individuals are put into place. Mark Thompson, the Registrar General for England and Wales, has said that he wanted to, and I quote, modernise registration procedures. Thirdly, the capacity to marriage should be established via a simple questionnaire to alert registrars that an assessment of capacity may be needed before the ceremony is carried out, and that perhaps a medical capacity assessment may also be required. Simply smiling at a marriage ceremony should not be assumed to mean consent if there is no mental capacity to make such a decision in the first place. Fourthly, Madam Deputy Speaker, notices of intention of marriage should be published on the internet. Families like Daphne's could have discovered much, much sooner that the marriage had taken place or was to take place, even if their presence was not requested or wanted. I'd like to thank Daphne and Stephen Franks for bringing their very distressing case to my attention as their local Member of Parliament, a case which I believe has profound implications for many hundreds of other families who may find themselves in a similar situation across the country, and of course it goes without saying many other members in this House. I'd also like to thank Sarah Young, a solicitor and partner in the firm of Ridley and Hall in Leeds, who has specialised in marriage law, for her help and advice in bringing this to the attention of honourable and right honourable members of this House. And I hope also to the attention of the government and to my colleagues on the opposition front bench.
The question is that the honourable member have leave to bring in the bill. As many as are of that opinion say aye. Aye. The contrary no. I think the ayes have it. The ayes have it. Who will prepare and bring in the bill?
Rachel Reeves, Alex Sobel, Tracy Crouch, Alex Shelbrook, Preet Kaur Gill, Caroline Lucas, Sir Edward Davey, Karen Lee, Richard Burden, and myself.
Fabian Hamilton.
Marriage and Civil Partnership Consent Bill.
Second reading what day?
The 25th of January 2019, Madam Deputy Speaker.
The 25th of January 2019. Thank you. Thank you. The clerk will now proceed to read the orders of the day.